the federal government has finalized its public charge rule. This is the rule that was proposed in September of 2018, and it has now been finalized almost a year later, coming out of the Department of Homeland Security. And that's important because there are other public charge rules, but we'll talk about that later. It's titled Inadmissibility on Public Charge Grounds. It essentially changes the definition of who is considered a public charge, or someone that could be deemed a burden on the United States should they change their status. The current definition actually is quite narrow. The proposed rule wanted to broaden that definition out to include people that were getting cash assistance and non-cash assistance. And that's benefits like Medicaid, food assistance, housing assistance, and energy assistance. So if you were someone that was trying to legally change your status to become a more permanent resident, this would impact you. So the rule was proposed, it got over 200,000 comments. Then there was the waiting period while the Department of Homeland Security went back and revised the rule and made a couple changes, and it has now been finalized. In the meantime, of course, they did change the director of that agency, and now we have a new director of Homeland Security with a much more aggressive stance on legal immigration. So the biggest impact of this final rule is to new arrivals, individuals seeking to immigrate to be with their families. The rule in its proposed state and also in its final state gives discretion to USCIS immigration officers to reject applications for admission. It includes those people who are on temporary visas who seek to stay permanently. This includes students and workers, so lawfully present on a visa, seeking to change your status, and you will now have to go through the assessment of whether or not you should be admitted. They're going to look at both positive factors, and included in the list will be your education status, your wealth, your age, do you have access to insurance, and negative factors. And that's where this public charge determination comes in. And use of things like Medicaid, public benefits, food assistance, housing assistance will be considered a negative factor. It's not a definite no, but it is a negative factor to your admissibility. Now, like we said, there are other rules in other departments. The State Department, for example, already has changes to its public charge rule that looks like this final rule coming out of Homeland Security, a little bit more strict with how it's going to judge people based on the types of public benefits that they're using. So now let's take a couple seconds to talk about how the final rule is different from the proposed rule we saw last September. The final rule has actually softened a little bit by the types of immigrant benefits that are in use, but looking at the population specifically, they had so many comments. The Department of Homeland Security had, like I said, over 200,000 comments, and a lot of them said you can't be judging immigrant children as harshly as you are. So they did soften some of the requirements in this regard. So let's look at those individually. First of all, in the original proposal, the Department of Homeland Security asked commenters to tell them about the Children's Health Insurance Program. It didn't say it would be used as a negative factor. It said, how should we use the Children's Health Insurance Program? And the resounding answer was, you cannot use that as a negative factor. So they actually abided by that. The Department of Homeland Security says that participation in the Children's Health Insurance Program, so these are children that are a little bit over the income limit for Medicaid participation, but still considered relatively lower income, that will not be a negative factor. They then also struck Medicare Part D benefits, the prescription drug benefit. Participation in Part D also will no longer be considered a negative factor. That actually is a change from the proposed rule that said it would be used against you. A big change was participation in the Women, Infant, and Children program, WIC, which is a nutritional benefit for young children and mothers. Using the WIC program will not be a negative factor for immigrant families. Now, if you use Medicaid as a child, a pregnant woman, or 60 days postpartum, that is no longer considered a negative factor. That's another big change from the proposed rule. So these were seen by the advocacy and immigrant community to be a big enhancement to get rid of a lot of the terrible negative effect of the rule, but that's just an asterisk in the overall consensus that this is still a terrible rule. Let's look at a couple other changes from the proposed rule, and then we'll talk more about impact. So the Affordable Care Tax Subsidy participation is not considered a negative factor. That was consistent with the way the proposed rule was written before, but they've tweaked the wording of that a little bit in the final version to say, Actually, if you use the Affordable Care Act without tax subsidies, we're actually going to use that as a positive factor. So you can't lose a point for having tax subsidies in the marketplace, but you can gain a point by using private insurance without getting any tax subsidy support on your premiums, which is just a wealth test. That just means that you're above 400% of the federal poverty level. In many instances. And so they're looking for folks that can, as the language of the rule consistently says, that can support themselves without any dependence on the government. You see the language of dependence and independence throughout this rule, just like we did in the proposed version. Now, the rule also excludes immigrants who have enlisted in the military, even if they are using public benefits, and this does include their spouse and children. And immigrants likely subject to public charge can post a bond. And I mention this because the dollar amount of the bond has changed. It's now closer to $8,000 instead of the proposed version that was $10,000. That's a bond that you can use while you're in the United States to be returned to you if you leave the country. It's a nice way for the federal government to hold a little bit of money from immigrant families when they're coming into the United States. Clarifications in the rule, and this is a good time to mention this again. This was stated in the proposed version, but they reiterate it to make it clear in the final version, was that the rule is actually looking at the public benefit user immigrant herself, not other family members. So if you have a mother who is an immigrant on a worker visa and she has U.S. citizen children, for example, use of public benefits by the children should not impact or make the immigrant mother considered a public charge because other family members are using benefits. They're going to look just at the benefits being used by that individual under consideration. But remember, this is a very subjective test by immigration officers. They're going to determine if you're likely to become a public charge, not that you have all of these public benefits and each one is a point deduction based on your overall score of admissibility. They're going to say, well, you have all of these family members that are using public benefits. Maybe that makes you likely to be considered a public charge. So it's subjective. The wording is likely, it's not for sure, which leaves a lot of room for interpretation for these immigration officers who are now trying to abide by both State Department and USCIS rules. Let's look at what's next. This is a rule that will be posted in the Federal Register on August 14th. It takes effect October 15th, so 60 days from post. There is a public comment period that happens with every final rule that is open. There isn't a lot of consensus that USCIS will be changing a lot of the wording in here. The proposed rule was about 400 pages. The final rule is well over 800 pages, closer to 900. They spent almost a year finalizing the language in this rule. There is the opportunity for public comment. The instructions are in the Federal Register. We link to those in the final version of the rule. But there's not a lot of room for change that we can see coming out of this administration. In fact, you will actually see in the next couple of months that the State Department is going to be tightening its rule to look more like this final rule, even though they already have a public charge rule on the books. The anticipation is that they will be tweaking their rules to be more consistent. Similarly, the Department of Justice will be tweaking rules to mimic these public charge rules coming out of Homeland Security. There's also a rule in front of the Budget Committee that looks at what you can do for deportation once someone is deemed a public charge. So we can expect that rule to come down the road as well. Now, with this anticipation of these changes to all of these rules, we know what the impact is on immigrant families because we've already seen it. The chill factor, number one, immigrant families have already, before this rule was even implemented, over the last year, there has been a steep decline in public benefit participation from people that are legally entitled to these benefits. And that's the kicker of the whole thing. Folks have legal entitlement to public benefits based on the immigration status they have right now, and that can now be used against them as of October 15th. So you're going to see a lot of conflict of legal entitlement versus negatively weighted factors for changing your status. As you can assume, lawsuits will ensue. A couple immigration advocacy groups have already indicated their intent to sue, and others are already filing papers. What else you can see? Well, the direct impact is on the public benefit user herself, and we can see a lot of lawfully present immigrants no longer having access to public benefits. The State Department has estimated that the folks under their purview, about 500,000 of them are using public benefits. USCIS and Homeland Security has estimated their numbers to be between 300,000 and 400,000 people. That seems low, but the projections that most people are looking at are those unintended consequences, the indirect impact. All of the children and pregnant women and refugees and asylees, the people that this rule should not be directly impacting, are the ones that are going to stop using public benefits, because the nuance of who counts and who doesn't is too slight. We know that families and children, even U.S. citizen children, will stop using public benefits so that that public charge consideration isn't impacted on the family as a whole. Like we said, lawsuits will follow. And again, we already know that refugees and asylees have stopped using public benefits, even though this rule has nothing to do with them. You can read a copy of this final rule. There are instructions of how to submit your public comment. You have 60 days to do so. We will come back and talk to you more about public comments and that October 15th implementation date. Thanks for joining us.